documentaries on Supreme Court cases. Maybe some of you have seen some of them, but this is a case we've been working on for a year. I've been working on with some law students here. Adam. Is Liz here? Liz Krimmer. Kimberly Beatty is also, is Kimberly here? They've seen it. They're probably sick of it. But we've been up to New London 3 or 4 times to interview the participants, and our goal is very much to bring the cases alive. I believe that this is the case method simply to a new generation. And these are wonderful people with wonderful stories. The other person working on the project who I see here is Sarah Wood, who graduated from the law school a couple of years ago. Put your hand up, Sarah. And is sort of, we don't know what our titles are, assistant producer, or I'm the assistant producer and she's the head producer. But we do want to start right on time. The video takes about 25 minutes. We then have a panel, Chris Schrader, John Hart, and Jonathan Wiener. Most of you know at least Chris Schrader and Jonathan Wiener, who both teach in the environmental law and the property law area, and John Hart has taught as an adjunct member some advanced courses. So without further ado, dim the lights, no popcorn today, next time.
This eminent domain here was not for a bridge or a road or a school. This was simply somebody else wanted to live here. This is so private people could make money off where I lived and my neighbors lived.
Give us a chance to compete for the big economic engines, the office parks, the industrial parks, and the retail shopping centers. They need large parcels of land. The only way you do it is through the use of eminent domain.
New London, Connecticut is one of America's oldest cities.
It's a great city. It is halfway between New York and Boston, on the water. It's simply ideally located.
Recently, however, New London has had its share of problems, as explained by City Attorney Tom Londrigan and local developer Michael Joplin.
We are, according to state statute guidelines, a distressed municipality. First of all, we've suffered a declining population since about the 1980s. We have doubled the unemployment rate than the state of Connecticut. And on top of all of that, approximately 56% of the land base of New London is non-taxable.
What we've been doing here in New London is either treading water in terms of the condition of the city, or we've been managing decline.
Local attorney Edward O'Connell explains why a small tax base was a problem for New London.
In Connecticut, the property tax is the prime method that municipalities use to raise their revenues to pay their teachers, their firemen, their policemen, pave their streets, run their schools. We have the Coast Guard Academy, Connecticut College, various churches. So we have all the various tax-exempt institutions and very little taxable land left.
We are 1 mile wide, 6 miles long. That's it.
New London has nowhere to expand to increase its tax base. Since it's an old community, it is fully developed. The other towns around here have enormous areas to expand in. If you wanted to build an industrial park in Norwich, well, you'd have your choice of 10 different places to build it.
New London took a hard economic hit in the 1990s.
New London got some bad news. The Navy Underwater Sound Lab was consolidated with a facility up in Newport, Rhode Island.
They were engineers and very sophisticated engineers. They were the people who developed a lot of the underwater sonar equipment and the communications equipment.
We lost 1,800 jobs and the base closed.
But in 1998, while the city was still reeling from the loss of its Navy base, New London got some good news. Pfizer, a large pharmaceutical company that already had a major operation across the river in Groton, Connecticut, announced that it would build its global research facility in New London.
This was a global research facility that every economic development coordinator in every country, state, and county in the world would have wanted in their location.
The site for the Pfizer complex was on the Thames River, adjacent to the Fort Trumbull area of New London.
Now, they did have some demands on the state of Connecticut. There was a Calamari's junkyard north of their site, and they wanted that remediated. Immediately to the north was the regional sewer plant, and it smelled. Pfizer said we would like that facility to be the state of the art.
And the third thing they wanted to do was see if we could do something about the Fort Trumbull neighborhood, but not anything in particular.
The Pfizer facility would inevitably affect those like Susette Kelo, who lived in Fort Trumbull. Kelo had grown up near the fort and had recently moved back there. She liked the neighborhood, and it was affordable.
It's a nice neighborhood. It was working class people. I mean, sure, I would have loved to have bought a house on the point for $400 million, but, you know, obviously I couldn't afford that. It was a safe neighborhood, and we certainly wasn't anything wrong with the neighborhood. There were houses. There were probably 75 to 80 homes here. Some of them single family, some of them two family. Some of them were a little run down, but most of them were nice Victorian houses.
Kelo began fixing up her house, including a new paint job.
By the water, salmon pink, you know, just sort of liked it. When I went to the close, and the lady that I bought the house for, she was kind of old, crotchety, old thing. And I had already painted the house by the time we had the closing, and she goes, well, that's an interesting color. I said, I wanted to brighten up the neighborhood. She goes, looks like you did. Something like that.
Kelo first read about Pfizer's plans in the local newspaper.
And they said that Pfizer's was coming to town, and they were going to have a development, which included the Fort Trumbull neighborhood. The residents were going to be asked to sell their homes, and if they didn't sell their homes, they were going to be taken by eminent domain. First you read it and you're like, oh yeah, right, New London. It's sort of like New London's always trying to do something, and everything it does fails.
But there was substance to the story. The state of Connecticut was planning to give New London a major grant to redevelop Fort Trumbull.
The state of Connecticut came to the city of New London and said, in effect, how would you like $70 million for a development plan to connect what Pfizer is building with your downtown to the north? It's a tough question. Do we want it or do we not want $70 million? For years, New London has seen state monies go to Bridgeport, go to New Haven, go to Hartford. New London never got anything. And so we said yes, we would. We need it.
The City Council authorized the New London Development Corporation, a local nonprofit agency, to develop a comprehensive plan for Fort Trumbull.
NLDC is an agent for the city. We are funded by the state. Our mission is to basically change the economic status of the city. It's about tax revenue, and it's about creation of jobs. It's about changing the image of this city.
Almost immediately, the NLDC began to acquire properties in the fort. Some of the owners were willing to sell.
All the absentee people, the people that didn't live here, sold. No sooner did they buy them, they would apply for a demolition permit and take them down. And their theory behind tearing down all the houses was that we wouldn't have anything to fight for if we ever got around to fighting, because everything would be gone.
As more information became public, Kelo grew more concerned. She spoke with a local politician who advised her to contact Kathleen Mitchell, a community activist.
I got a call from Susette, and I had never met her before, and she's yelling and carrying on. They're going to take my house. They're going to take all of the houses. They're going to take every house here. They're going to demolish them. And I said, oh my God, this woman's nuts. But I thought, well, at the very least, they're probably going to try to take her house. So I agreed to help her. I began to think of the usual things, you know, publicity, walks, letters to the editor.
She says, well, the first thing you got to do is you got to put in a press release and you got to have meetings. So I said, okay, Kathleen. We handed out flyers and we had petitions. And then, you know, that's when the newspaper reporters came. What are you going to do? Well, I'm not going to sell. You know, what are you going to do? I'm going to fight it.
Mitchell also suggested a neighborhood meeting.
We talked about what we were going to do to try to stop them. They wanted to know what I was going to do to help them.
She would call me every day early in the morning, and we would talk all day long, what can we do next?
Kelo became an advocate to save the neighborhood.
I went to a city council meeting. This was Kathleen's idea, because all of them were so old that, you know, they couldn't go to these meetings. You know, I asked them to each write something so I could bring it to the city council meeting and read them. Mrs. Pasqualini wrote, I married my husband, you know, 60 years ago. I've never lived anywhere else. I raised my children here. Please don't make us move.
Others soon became concerned with the plight of the Fort Trumbull residents. One of them was Sally Ryan, head of New London Landmarks, a group dedicated to preserving New London's historical buildings and neighborhoods.
Our aim has always been to work for the preservation of the historic New London. And we should try and help these people to preserve their homes.
Ryan helped found a grassroots organization known as the Coalition to Save the Fort Trumbull Neighborhood. As an initial step, Ryan investigated whether Fort Trumbull could be designated as a historic landmark area.
Landmarks had paid for a study of that neighborhood. We had a lot of documentation on all the houses. It didn't have the hook to get it on the National Register.
But even without formal designation, coalition members thought Fort Trumbull was worth saving.
This was a really special neighborhood. It was built by first Irish immigrants and then Italian immigrants. You could look at different buildings and see the masonry, the brickwork that was used. There were little Italian gardens in these various houses.
The rumors that reached us were that Pfizer didn't want this little, slightly shabby neighborhood right next door. And what we have heard is that there was a closed-door deal between Governor Rowland at the time and Pfizer that, they would move to New London and the neighborhood would go.
Coalition members were also united in their distrust of the NLDC's development plans, given New London's history of so-called urban renewal.
I've seen redevelopment, I've seen eminent domain, I've seen them clear property, and it doesn't work.
They destroyed some beautiful homes and neighborhoods all around downtown New London. Thought after that record that we had learned our lesson. We didn't. But, the definition of madness is to do the same thing over and over again and expect different results.
We were astonished that people in New London would say, fine, let's do it again. But they were told that it's different. This is a unique combination of academic brains and corporate money and private-public partnerships, and it would be different this time.
From the city's perspective, while Fort Trumbull had great potential, it had many problems.
It had a junkyard. It had an abandoned Amtrak railroad yard. It had an oil tank field. A rough, tough area. And I think the majority of the people felt that finally somebody was going to do something to help this area of town.
New London faced an initial choice. It could proceed to acquire the property under a Connecticut statute to promote economic development, or under a statute to revitalize areas that were run down or blighted.
This area certainly qualified for the blight statute, had an 80% commercial vacancy rate. 80% in a commercial zone. The housing stock, 88% of the stock were deemed poor to fair.
There were some homeowners that had properties that were well maintained, but blight doesn't necessarily mean that there is no good property there. It just means it's a characteristic of the area, and this met those characteristics.
The state of Connecticut decided not to give the money to the local redevelopment agency to proceed under the blight statute. Instead, they gave the money to NLDC to go under Chapter 132, Economic Development.
The NLDC retained engineers, architects, and environmental experts to study Fort Trumbull and develop a comprehensive plan.
We collected the right consultants to answer the question, what is the highest and best use of this land? The answer to that question is in the context of the community at large.
It's been zoned industrial and commercial since 1929. A plan of development has never changed in close to 80 years. Industrial and commercial is the future for this.
Work began immediately to improve the former Navy base, which included restoring Fort Trumbull itself, a fort built in the 19th century as part of America's coastal defense system.
Now, I was born and raised in New London. I had never seen that fort from the water or from the land, because the military built buildings that surrounded it. And Pfizer knew of the plans for the state of Connecticut to renovate that. And when asked when it was going to be done, well, we're going to have about a 10-year plan to renovate it. Pfizer said, how about doing it in 2 years? The governor used to love telling the story about how people said, when did you build that fort?
Many of the industrial sites in the fort had been designated brownfields because of contamination.
Virtually all the site was polluted and needed environmental remediation. A former Amtrak Maintenance Away rail yard was a environmental nightmare. We've found that every single parcel we've touched, including all the residential parcels, has exceeded the state's criteria for residential direct exposure of contaminants, primarily arsenic and lead.
The plan also called for a complete overhaul of the area's infrastructure.
We then worked with design engineers that were primarily civil engineers in terms of improving the streets and the rights-of-way and the infrastructure and getting that put in. So it really was a case where all new infrastructure was required.
The culmination of the NLDC's work was a comprehensive plan known as a Municipal Development Plan.
It's really for a plan for 90 acres. They divide it into various parcels for ease of administration, but it's not 6 or 7 different plans. It's one plan for the entire area. Contemplates a museum, shops, taking advantage of the waterfront, office. Those are the type of uses that would attract people to New London and get New London hopefully back on its feet.
We can create parcels, we can redraw the lot lines, we can offer to a developer a 3-acre parcel, a 4-acre parcel on which they can build 100,000 square feet of office space, or they could build 80 units of housing and basically reinvent the area.
In August 1999, the NLDC formally presented its draft plan that called for the removal of all the homes to prepare the site for an extensive mixed-use development. Coalition members met with the NLDC to voice their concerns.
And I said, well, as I understand it, this is a draft, and that there are public hearings, mandatory public hearings before this thing goes through, before it's actually voted on. And I'm a professor. A draft means you can change it. And all we were saying, amend the plan, do everything you plan to do, but amend it to incorporate the existing homes and businesses into this splendid development.
They got like 50 acres of prime waterfront property. Myself and my neighbor's home, we take up a little over 1.25 acres. And certainly we've never been against the development. We welcome the development. Build whatever you want to build. Just let us stay. If I can't live here, no one's going to live here.
It just seemed senseless, and they never gave a reason. They never said, this is why they have to go. And once I went to a city councilor at the time and said, why are you going to do this? And he said, because we wanna. Just like that, because we wanna.
Public review of the plan culminated in a hearing where the NLDC presented the Municipal Development Plan and its reasons for removing the homes.
It is not good planning to put single-family detached homes with the backyard, the front porch, the picket fence across the street from a regional sewer facility.
You know, I moved here with the sewage treatment plant here, with the scrap metal yard here, with the marina here. I didn't move here to complain and change the neighborhood.
In January 2000, the NLDC presented the plan to the City Council for approval.
The meeting lasted for about 4 or 5 hours. Everybody got up and spoke. We begged and pleaded for them not to do this. And then it came time for them to vote. It took about 2 minutes, and they voted to remove us all by eminent domain.
There has to be somebody who makes the tough decision. In this case, it was the elected officials for the City of New London. The fact that somebody loses does not mean that the majority didn't listen to them.
They had their marching orders from the state. If we don't take all the homes by eminent domain and do this plan, the state isn't going to give us $78 million.
The City Council also formally authorized the NLDC to implement the plan and to use eminent domain if necessary to acquire all remaining properties.
The City Council decided to adopt this development plan, seize this once in a lifetime, once in the history of the city and London opportunity, and go forward.
Coalition members were demoralized.
There were fights, there were tears, there was a lot of struggle over what do we do, and we decided, well, let's just keep trying.
The coalition had previously considered hiring a lawyer, but it would have been too expensive. At that point, coalition member Peter KRECKOVIC came up with an idea.
I really felt we needed some outside help before these houses were leveled. And at that point, I heard of the Institute for Justice. So I told the coalition that I would follow up on this, so I wrote the Institute for Justice a letter.
I read that letter, said, you know, this looks like the type of case that we are looking for.
Scott Bullock was an attorney with the Institute for Justice, a public interest law firm dedicated to protecting individual liberty. One of the Institute's major initiatives was to stop eminent domain abuse.
We're talking about one of the most awesome powers a government has at its disposal, eminent domain. The ability to remove you from your home, from your small business, from your land, apart from putting you in jail. That's about the most serious thing a government can do to you.
While most property owners had sold their homes, a few continued to fight. In November 2000, the NLDC instituted eminent domain proceedings to take the remaining homes. The Institute for Justice filed suit on behalf of Kelo and 6 other landowners who owned a total of 15 properties. Bullock's argument was simple. The Fifth Amendment to the Constitution requires that there be a public use to justify taking private property.
We challenged it on the grounds that taking land from A to B, simply in the name of private economic development, commercial development, was not a public use.
So what is a public use? You know, does it have to be a school, a post office, a fire department, or is developing an economy which will sustain jobs and produce tax revenue so that a city can meet its primary obligations of public education? Is that a public use? I would argue it is.
New London's lawyers prepared to defend the plan in court.
The Institute for Justice said, you know, we really don't need a trial. There are no facts in dispute. Why don't we just stipulate to the facts and argue the case? We said no, we want a trial. We wanted the judge to hear our experts.
During the 7-day trial, New London offered the testimony of several experts, including an urban planner who testified that it would be a mistake to permit a few homes to remain.
He said, I don't recommend leaving these 7 plaintiffs where they are. It's like the spotted leopard. The judge said, well, what do you mean by that? He says, it's like spots on a leopard. You have to find a developer and tell him, come to this parcel of land, but, by the way, you see that single-family house over there? You've got to design your complex around them. Oh, and by the way, there's another spot over here. And he said, Your Honor, you're not going to find a developer to come in and handle those type of challenges.
Bullock countered by suggesting that the plan was not driven by any sense of public benefit, but rather by what Pfizer, a private company, wanted.
They played a very key role in putting together the municipal development plan. One of even the city's experts did describe them as the 10,000-pound gorilla. Pfizer wanted a 5-star luxury hotel for their guests and people that were coming to visit them. They wanted upscale condominiums for scientists that were working there on short-term stays and so forth. And they wanted office space for people that do business with Pfizer. And at the end of the day, guess what was put in the municipal development plan? A 5-star luxury hotel, upscale condominiums, and private office space.
Bullock was critical of the NLDC's planning efforts, citing as an example one particular decision.
But they managed to salvage one building, the Italian Dramatic Club, which is a private, men's-only social club, very popular, and lo and behold, the NLDC and its planning process found a way to save the Italian Dramatic Club. Somebody put it one time, is that the Italian Dramatic Club can stay, just all the Italians have to go.
Bullock argued to the court that the proposed development in the areas where the plaintiffs lived was highly speculative.
The evidence that we produced in the trial demonstrated that the office building was not going to be built any time in the foreseeable future because there was no market for it. In Parcel 4A, they could not even say what the property was going to be used for. It could be parking, could be retail, could be a museum.
This is how the argument was presented to us. Do you have a developer? You answer that question, no, I don't have a developer. You're plain speculative. It's vague. You're taking somebody's property and you don't even know what you're going to do with it. It's unconstitutional. Okay. I have a developer. You have a developer? Yes. Oh, you're taking property from A and giving it to B.
You should at the very least have to name the use, and there has to be at least a reasonable certainty that the property is going to be used in the way they say it is going to be used for.
The key to the case was whether taking the plaintiff's properties for future development constituted a public use.
New London was justifying its condemnations simply upon its ability to raise more tax revenue and create more jobs. They were simply relying on the fact that they think that the new owners of the property would be able to put the property to more productive use. If that was not stopped, then there really are no limits on eminent domain authority. Every home would produce more tax revenue if it were a business. In America, should the government be able to take your home to give to Walmart? People would say, of course not.
I hear cases of Walmart coming to town and saying, I want that block. The municipality takes the property, does nothing with it, and gives it to Walmart. That's wrong. That's terrible. That's not what we did in New London. We took 90 acres of land. We put basically $70 million into the ground. We remediated a brownfield site. We reshaped it. We reformed it. We put in new roads, sewer, public walkways, access to the water. That's what we did with the land. Those are significant public uses and public benefits.
The trial judge held that the NLDC was justified in taking some of the properties, but not others.
So how did he split the baby? He said economic development is a public use. That's fine. You can go forward with your plan on all the parcels except 4. You have to make your proposed use there more specific.
Both sides appealed. In a divided decision, the Connecticut Supreme Court ruled in favor of New London, holding that economic development was a public use that justified taking all the properties. The Institute for Justice filed a petition for certiorari with the United States Supreme Court. The court accepted the case, setting the stage for the most important property dispute in decades.
If I'm going to be thrown out of my house, the whole world's going to know about it.
Thank you. Why don't we invite our panel to come up here? One of the, I send these to my mother, and she always calls up sometime 10 o'clock, and she won't say hello or anything. She says, well, what happened? And I say, well, you're supposed to go to class and talk about it. So we will do that now, and we have 3 property law experts and environmental law experts. And Chris, go ahead and start us off.
Where's the picket line for Susette Kelo? I want to join it. They can't do that to her. Except the Supreme Court said, of course, they could. When the U.S. Supreme Court finally answered this question. I just want to make 2 comments about the case because we want to be brief. One, to observe that had the case come out the other way, I would have been quite surprised. There are actually a couple of Supreme Court decisions that I thought came pretty close, some couple 20-year-old decisions that I thought came pretty close to answering this question in favor of New London. So I would have been, stood up and taken notice if the court had come out the other way and thought that the outcome was fairly predictable and within the kind of conception of the way municipalities have been operating for years under their eminent domain power. But who knew? The vast majority of America was outraged by this decision. They didn't understand it at all. Just shows you that professors don't know as much as the fellow in the film says that they sometimes do. This case has been very controversial. At least 20 states, I think more, have put provisions on the ballot in the last election cycle to limit by statute the power of eminent domain. And one of them, Florida's, even takes away the eminent domain power entirely, so that the municipality, except for some very narrow exceptions, I think, would have to negotiate with every individual property owner before any use of property by the state could be put if you had a similar situation. So we haven't seen the last of the repercussions from Kelo, and maybe Jonathan and John are going to talk a little bit more about those. I won't, as I say, in order to be brief. I just want to say one other thing about the film. It's a very nice interweaving of the two sides of the story. So you see the city side and you see the side of the landowners being interleaved throughout the story. It's typically not the way the media covers these stories. In the beginning, the coverage tends to be heavily emphasizing the nature of the community development plan or the other action the city is taking to beautify the city or do something for the greater good. And you don't hear not much about the individual property owners. You hear a little, but the coverage tends to be emphasizing the public good nature of the case. And then as it proceeds along, at some point in time, as these cases get controversial, the media coverage shifts, and they begin to focus more and more on the individual stories, particularly if there's a attractive holdout, as there were a number of them in this instance. The media love to write the story of the little guy standing up against the big guy, particularly when you have a couple of big guys. It's not only the state, it's Pfizer sort of lurking in the background in this situation. The David and Goliath story is really easy to write and is attractive. Our distrust of government runs awfully high, and these situations bring out the sense that the government's up to something that's no good. And of course, there's just a sympathetic, terribly sympathetic nature to these situations of property owners being uprooted against their will and forced into all the disruptions that entails. And then, of course, if you can finally catch the government in making a few mistakes or missteps, as apparently happened here, like the city council member sort of blowing off one of the landowners by saying, just because we want to is the reason that we're going to do this. You've got the makings of the kind of grade A conflict story that the media loves to focus on. And that certainly was evident as this case was wending its way through the courts in Connecticut and then as it became a national issue. So the dynamics here, I think, are quite interesting, and as far as the public story goes, I think end up leaving you with an impression that the city of New London is engaging in some really obnoxious predatory behavior. I think the work that Tom and his colleagues did in showing you both sides of the picture present a more nuanced look so that you can at least appreciate what the arguments are on each side of the question. So I commend them for a very fine job. First time I've seen the film, and I appreciate the opportunity.
Well, I think there are at least two topics we can discuss today. One is the Kelo decision and property law and takings law, and the other is the film, the documentary film. And so the nominees for Best Documentary on Takings Law include The Public Use Labyrinth, The Dispossessed, that's the Scorsese film, and Little Miss Holdout. But the Oscar goes to The Battle for New London, Thomas Metzloff and Sarah Wood, director. I couldn't resist that. I grew up in a town a lot like New London, Croton-on-Hudson, New York, on the Hudson River, and there, when I was a kid, the big industry was the railroad, and that was closing. The railroad yards occupied most of the land area or a lot of the land area of the town, and were supplied jobs for most of the breadwinners, and that was closing. And there was a similar question about what to do. In our town, the situation was sort of the opposite. That is, the railroads were replaced by condominiums and housing near the river, rather than the housing near the river being replaced by industry. But I think it's fair to say that this kind of situation is going on in towns all over in one way or another, and that's one reason this case resonates so much. It's not just New London and Susette Kelo, but these have become icons for much more widespread set of disputes. And it may also be fair to say that everybody hates the Kelo decision. Conservatives hate it because it's upholding the power of big government to take property from private owners. And liberals hate it because it took from the poor to give to the rich, took from Susette Kelo to give, in effect, if not directly, but in effect to help Pfizer. But I think that both of those reactions are overstated, and that The real significance of the Kelo case is much more mundane, much less dramatic. And there have been some nice articles, for example, on property scholars attempting to rebut the liberal concern that it's taking from the poor to give to the rich, which I might add is not only a liberal concern. If you read Justice O'Connor's dissent in the Kelo decision, she makes this same argument that what's most galling about the Kelo case is that it was taking from low-income owners to give to big industry. But there are articles, for example, by Peter Byrne at Georgetown arguing actually these economic redevelopment or removal of blight, whatever you want to call it, these urban programs are much more likely to benefit low-income, across the country, to benefit low-income populations than to harm them. And there's a nice recent article by my former student, Abraham Bell, and Gideon Parchamovsky on why if towns can't do what New London did, they may do worse things. And so the eminent domain power may be the least worst option from the perspective of private landowners. And that is, I think, there is a strong be careful what you wish for point here in this case. If she had won, if Susette Kelo had won this case, or the Institute for Justice had won this case, one possible logical outcome is that governments would increasingly take land and keep it in public ownership. And so rather than having private markets fostered, it would foster a bigger state. And that would be, one would assume, at odds with the interests of at least of the Institute for Justice and the ideology of private property. But I want to say I think this case is less than meets the eye, partly for the reason Chris said. There were earlier decisions, the Hawaii Housing Authority v. Midkiff, essentially saying the same thing, that there's a broad domain of what counts as public use, and economic development or economic progress counts as part of the kinds of uses that public use will cover. And so it would have been much more surprising if the Supreme Court had ruled the other way. And from that perspective, also, Justice O'Connor's dissenting opinion is the most interesting, because she wrote the majority in Hawaii Housing Authority versus Midkiff, and now she writes a dissent here. And in her dissent in Kelo, she says there was, quote, errant language in Hawaii Housing Authority v. Midkiff, in particular her own sentence that the reach of the public use test is coterminous with the police power, which she now seems wanted to step back from. So looking forward, now with Justice O'Connor retired, it'll be very interesting to see whether the posture of the Supreme Court shifts on this kind of question with a new chief and a new member succeeding Justice O'Connor. So nonetheless, I want to say this is not so unusual. There are many doctrines in American law in which the government shifts property from one user to another. So adverse possession is perhaps the most familiar to first-year property students. And in adverse possession, you don't get any compensation. Some scholars argue you should, but one way to look at adverse possession is it's punishing the owner who doesn't make highly productive use of the land, and that's, in a sense, exactly what's going on with eminent domain. The government is saying, we've made a legislative judgment that you haven't been making as good use of the land as we could, or as we could direct, and so we're going to take it from you, and we'll pay you compensation, which is better than you get with adverse possession. But there are a lot of other doctrines, compulsory licenses for intellectual property, the tax and spend power in general, when the Fed changes interest rates, that in effect shifts property from A to B, or shifts relative wealth. And certainly tort liability or liability rules in general. And some of those you get compensation, some of those you don't. I think what's the real issue here in the Kelo case is not shifting of property from A to B, or shifting of the benefits and burdens of economic life, as the court has said in other takings cases. The real issue is concentrated power. The reason that Hawaii Housing Authority versus Midkiff was not so controversial was that that was a case in which the state took property from concentrated oligopolist landowners and gave it to the numerous dispersed little guys, to the rental tenants. in order to break up the oligopoly. Whereas in cases like Poletown in Michigan and Kelo here, governments were taking land from what seemed like the little guy, what was little guy, and giving it to big corporations. And that may be objectionable, but I don't think the solution to that is in the public use test of the takings clause. The solution to that is in anti-corruption legislation. And one issue that wasn't raised in the film was that Connecticut, and I think the administration of Governor Rowland, if I'm not correct, was embroiled in other investigations and controversies about government corruption at about the same time.
Well, he was in jail. I couldn't interview him.
Yeah, okay. So the backdrop here is misuse of government power, not just the takings power, but misuse of that power. So anti-corruption law, maybe some version of antitrust law or some notion of competition policy that should inform takings doctrine. Zoning law. I thought it was interesting that the City of New London said, we've zoned this for industrial and commercial use the whole time. Maybe there shouldn't have been houses here to begin with. But certainly a town could zone land to prevent big industry from taking over. So there are all those kinds of uses. And the compensation requirement itself, the fact that the government will have to pay for the land, either through a negotiated payment or a liability payment, that should discourage excessive takings to a significant degree.
Eminent domain is not really an area that I paid much attention to until the Kelo case. And I will certainly stipulate that Ms. Kelo is a very sympathetic plaintiff, certainly blameless, not just a small owner, but the person who repainted her house in a blighted neighborhood. She certainly deserves to hang on to her house as much as anyone, but she's certainly not the first person who's sympathetic for those reasons. So I think the fact that the outrage comes now with Poletown and Kelo and did not come when the African-American neighborhoods were being destroyed in the 50s and 60s is a perspective that has to be taken into account. But the reason that I am interested in eminent domain is that I care a lot about the police power, the regulatory power, and they're part of the same part of the Constitution, the takings clause, and the takings doctrine has been metastasizing in recent years to the point where it is far beyond what even the Lochner Court enforced in the early 20th century. Now, the Lochner Court was certainly attentive to the interests and rights of property owners, so I think that's a fact that should get our attention. Now, the method that I'm interested in exploring with the takings clause is originalism, and the reason I'm interested in it is that basically that's the rhetoric and a lot of the logic of both the so-called property rights movement and the Supreme Court when it does expand, when it pursues an expansive view of the takings doctrine. Now, when I say expansive, I just mean expansive compared to an historical baseline, and there's several historical baselines you could take. But the public use, returning to the main subject, the public use doctrine is a judicial doctrine. If you were to classify it, it really is part of substantive due process. That's about the closest, and that's giving it the benefit of the doubt. It's a judicial doctrine that dates back to the 1840s. The 1840s has nothing, the founders were in the ground in the 1840s. So the people who started channeling the founders and testifying as to what the essential liberties that were preserved by the Constitution, the Declaration of Independence, etc., were sincere, but at least acting in reckless disregard of the historical record. Suspiciously enough, that historical record has been presented as a tighter and tighter warrant for the public use doctrine. I think that's the best test of any originalist argument, is to see when it began. Now, the most striking historical phrase is that you shouldn't take property from A and give it to B. Well, like many such slogans, if you read the case that came from, the context qualifies that almost to the point of meaninglessness. What the Circuit Court and Supreme Court said back in the 1790s, and these were just individual justices in seriatim opinions, what they said was that it would be fundamentally unjust to take property, to pass a private act taking the property of a named individual, A, and giving it to another named individual, B, when there was no public purpose. Now, you can follow that, you can look for several more decades, and you will find courts starting to express an impulse which was mostly anti-corporation in motivation. They started to express an impulse that something stronger ought to be required of the government when it was exercising, or especially delegating, because that's what we're really talking about here, delegating the eminent domain power. But they tried a lot of different things. The first thing they tried was necessity. And I think it's very significant that none of these courts, up until 1830s, 1840s, none of them linked the public use requirement with the language in the takings clause or in various state constitutions referring to takings for public use requiring compensation. Perhaps their knowledge of English grammar was superior to ours, but they realized that the question of taking property not for public use was an omitted case in the takings clause. And that's why they resorted to what they called fundamental principles of justice. But certainly by the time of the 14th Amendment, a number of states had their state courts and a few constitutions had adopted the position that eminent domain should only be used for either the use by the government, which would be the fortress, use by the public, the highway, or use that served the public, such as a grist mill. At the time of the 14th Amendment, some states held that. Some states held that any sort of economic benefit was a public use, sufficient to satisfy the public use doctrine, not to satisfy some literal meaning of the read into a takings clause. But certainly the issue was very much up in the air. There's no reason to think that the drafters or ratifiers of the 14th Amendment intended to adopt what some states were doing as far as restricting the use of eminent domain. And the U.S. Supreme Court, as Justice Thomas perceptively pointed out in his dissent in Kelo, U.S. Supreme Court never countenanced the narrow view of public use. They always accepted public benefit, including prosperity or resource development, as sufficient. So, but every wrong should have a remedy, and so I think that Mrs. Kelo's remedy lies elsewhere in the process. State statutes can protect people like Mrs. Kelo very easily, and a lot of states had already passed such statutes or even constitutional amendments. I think statutes are superior because when Florida learns that, as the 19th century judges like to point out, every society has exercised the power of eminent domain. When they realize the costs of their decision to forego eminent domain, I suspect they'll want to change it back, and that'll be easier if it's a statute than a state constitutional amendment.
I would like to have some time for some questions. So
Okay.
I think we've had about earlier. I have one quick one. It's really an environmental question. I heard so much from the city of New London folks about we have to save our cities. We have to recycle. They use that word. Probably it's a nice word. You all want to recycle, right? Because otherwise they'll go to Norwich and they'll go to and they'll build their buildings elsewhere, and New London dies. So, Chris and Jonathan, you both do environmental work. If you were the head of Save the Planet, some group, do you clearly come in on the side of Ms. Key? How do you view this case from an environmental perspective? Because they saw it that way.
Well, I don't know the facts in sufficient detail beyond what little came out in the case, and more actually came out in your video. There's a lot to be said, I think, for what they are attempting to do and maybe have already done from an environmental perspective. The brownfields problem is a huge problem. That's the situation of some contaminated land that no one wants to develop because the costs of rehabilitating it up to federal standards are inordinately expensive. And lots of cities have brownfields issues. It sounds like theirs were genuine and real. They're the kinds of industrial facilities and railroad repair facilities that are notorious for these kinds of problems. So that aspect of what they're doing, I think, is going to create more usable land for the city. I'm familiar with the way all of these Connecticut cities along the coastline are structured. They're all basically like New London. They're all 1 mile or less wide and 6 or 7 miles deep, and the development all tends to be along the I-95 corridor, which is about a mile off the coast or closer, and that's about all you can use. And so they've got a terrific problem. And the basic notion that you want to look at your areas that are like brownfields and try to rehabilitate them so that they can be infilled rather than sprawling out more into the Connecticut countryside is, I think, a sensible idea from an environmental perspective.
Well, I don't know the facts of New London's environmental issues in detail either, but I guess I would say I think it is accurate that towns see themselves and states see themselves as in competition with other towns and states to attract industry, jobs, and tax base. And so this kind of problem is rampant throughout environmental law and property law. And, you know, the zoning power has essentially been a series of clashes between two progressive values: environmental protection, stated one way or another, versus inclusion of outsiders, inclusion of in-migrants or low-income or minority populations. And so that kind of problem is not only in the takings law area but also in ordinary run-of-the-mill zoning decisions going on all the time.
Questions from our group, please?
I have 2 questions. Well, it's indisputable that if you build like a public school or a courthouse, that's public use. But when you have a development plan and a private development, what you're talking about is potential public welfare, and in the Kelo case, the city of New London maybe had reasonable belief that their project will result in the increase of the public welfare. Well, I don't recall that there being touch on that issue, but I mean, it's pretty clear that such belief should be reasonable, but what degree of likelihood of success the project should have to qualify, you know.
Let me state that question because it is on the web today. So, and I think it's a very good question, which is, what is this, which Scott Bullock talked about? How don't they have some proof that it's really going to work? That there's really going to be something to develop there? They come in with nice plans from architects. They got beautiful plans from architects. How do you know if something's really going to happen there? Should that be part of the constitutional test?
Well, it never has been, and I think if it's to be added to the eminent domain power, it should be added across the board to all government powers. The courts have never accepted a necessity requirement or a
not necessity, prediction of success.
Well, they've never accepted that either.
I think one distinction that's made in some of the opinions in Kelo case, I think Justice O'Connor makes this distinction, is that in Hawaii Housing v. Midkiff, the taking from the oligopoly owners accomplished the economic benefit regardless, almost, well, I think she says, I'm not quoting here, but regardless of to whom the property was given afterwards. That can't be quite right, because if the property was given to a single monopoly owner, it would have been even worse. But whereas, she says, in Kelo, if the property was going to achieve its public use benefits, it depended on the development plan actually succeeding. And so you might try to make that distinction about whether the public use is evident at the time of the contested government action.
Because for her property, they said it might be a parking lot because it's next to the fort. We might someday put the museum here, although we doubt it. It's not our preferred site. We might need it for the marina, which is next door, which if you've ever been to that marina, which I have, they ain't going to do a damn thing with that marina. They got a much better marina up the way. So it's kind of, you know, it's in the area. We might need it someday for something. So there's something to that argument that you should be pretty specific about what it is that you're going to do and a likelihood that it's going to happen.
I would just add I think the majority's answer to that in Kelo was, we can't say economic development never counts, and we are not in a good position to judge when economic development is likely to flow from this project or not. That we have to defer to the towns and the legislatures on that issue.
That's really an ultimate question, is how comfortable are we with leaving this to the political process? I mean, in a sense, we've seen the political process. London's one of the great little new Connecticut towns that are often in poli-sci textbooks and case books and stories. Can we really rely, is the Supreme Court right to rely on the political process?
Well, I think what the Supreme Court is doing is respecting the existing baseline of the legislative power. I think it would be fine to put any sort of restriction on the use of eminent domain, and some of them could be tailored to the most sympathetic victims. I mean, you could say that if a statute could say, or state constitutional amendment could say that where the purpose of condemnation of a residence is to build other residential property, maybe the person should have a life estate in one of the condos. I think that would be fine. But when you say leave the power in the legislative process, I think it's important to perceive that it is a matter of leaving the power. And if the legislature acting for the community is to be deprived of powers, that should occur through a majoritarian process, either statute or constitutional amendment.
Another question, please.
I studied economic development a bit in undergrad, and one of the biggest problems in a lot of countries is lack of respect for property rights, and people not believing them. Because they'll tell you have them, and then the next year they'll come bulldoze your house down. And it seemed to me that the takings clause, one of the most powerful things it did was it prevented states from kind of having a rush to the bottom to take property for whatever reason they want. And this seems to weaken that substantially from at least how the American public thought of things.
Encourages Miss Kelo to paint her house and fix it up.
Well, it just, yeah, I mean, she could underinvest or the value just go down, especially rural properties where people want to put in a new development or put in a new factory, that their property goes down in value because people know that they can get eminent domain for any commercial purpose now. Whereas before, maybe a road, maybe a school, not some profit-oriented organization. And I haven't read the decision, but did the Supreme Court talk about at all the reasons behind the takings clause, the protection of property rights? And
That decision was assigned in property law this past fall.
Yes, yes.
I have to interrupt on that. Just have to question that particular aspect of your comment.
Well, he didn't say it wasn't assigned. He said he hadn't read it.
I recognize that. Yes, I recognize that.
The only point I would make is that when you refer to the purpose of the takings clause, you're probably referring to something you've read that is not based in fact. Statutes were used by colonies and then states to take property, give it to economic enterprises for commercial purposes before the Bill of Rights was enacted and after the Bill of Rights was enacted. So the idea that the expansive use of eminent domain occurred in the 19th century and that it was an incursion on the original liberty, that's just not true. And there's no sign of any restrictive public use requirement in the legislative history either.
So I would just add, first of all, I'm sure you did read the opinion, but it's now that you're so absorbed in con law, torts, and crim law that you just don't remember. The second point is that I think that you're correct that the one purpose of the takings clause is to make property rights secure and thereby motivate investment and conservation of value of property, but that's mainly accomplished through the compensation requirement, not through the public use test. That is, people know that if the government takes their property, they're going to get paid for it. At least they're going to get paid fair market value. Now, that may not be enough, and maybe just compensation should be more than fair market value. I think that's certainly within the ambit of the words just compensation. But that's the primary protection.
Final thought?
Well,
and there are more questions. People can come down and chat with us.
Just with respect to Kelo itself, one of the things that interests me, and I think a lot of people, is whether Kelo will mark a change in people's behavior. I mean, as Tom's video showed you, Connecticut already had a statute on the books that allowed for use of eminent domain for economic development and then a separate one for blighted areas. One of the legislative initiatives that's been very popular is to try to get states to eliminate the economic development part of that so that you could still take property for blight. As they say, Florida went a step further and has eliminated it on both of those prongs. But I think if you had talked to planners, city planners circa 1999 or 2001, they would have told you they could do this. So that from their perspective, what will be interesting to see is, will the Supreme Court case cause them to be faster with the trigger on pulling the eminent domain pistol out of their belt and firing it? My sense is that and therefore will it make people less secure about their property on the other side? My sense is that the main reasons that the main explanatory variable for the frequency of eminent domain use has a whole lot to do with the kind of cultural norms of the state and localities involved than with the sense of what the legal boundaries are. I mean, eminent domain is very difficult to do in North Carolina because we still consider planning equivalent to communism. So it's a very tough political call for some local city council member to really say, I'm going to take somebody's property, even if it's for a very legitimate, traditionally recognized use. I'm told that one of the reasons that people in Florida decided to ban it entirely is because there was a lot of abusive behavior in Florida municipalities where there was a lot of growth going on. City councilmen and county commissioners decided, let's take somebody's property without much reflection on the idea at all. So I'm inclined to think that those kind of considerations weigh more on people's minds than the boundaries that the court has set. But this is going to be an interesting period of time to see actually whether these practices do change after the case.
Before we end, I just want to congratulate again Tom Metzloff and Sarah Wood and the students who worked on this, because I think this was terrific. I think we watched this for the first time just now, at least I did, and I certainly took a lot from it. And maybe if I had shown this in class, the case would be more memorable.
A student of yours.